We've just received some major updates in one of the most important suppressor cases currently in front of the Fifth Circuit en banc. In a surprising move, the DOJ, under the Trump administration, has changed its stance. They now acknowledge that suppressors are indeed protected arms and cannot be completely banned. This is a significant shift. The DOJ's latest brief walks back several key arguments they had previously made in this very case, arguments they've relied on for years. So in today's video, we're going to break down exactly what was said in this new filing, why it matters, and what this could mean for the future of suppressor laws. Before we get into the full details, if you'd like to support the channel without spending a dime, just hit that subscribe button. It helps us reach more people and shows the algorithm that this kind of 2A content matters to you. Also, leave a quick comment below. Anything positive helps keep this conversation moving and ensures more people get access to content like this. Let's take a closer look at what's going on. The Peterson case background: earlier this year, a 3-judge panel in the Fifth Circuit Court of Appeals issued a ruling in a case that's now become a major suppressor challenge. That case is United States v. Peterson, and it's currently being considered for en banc review by the full Fifth Circuit. At the center of this case is a direct challenge to the National Firearms Act, specifically whether its suppressor regulations violate the Second Amendment. Mr. Peterson was convicted under the NFA for possessing a suppressor, but he pushed back, arguing that these restrictions are unconstitutional. When the panel reviewed the case, they ruled that suppressors are not considered arms under the Second Amendment. That meant, in their view, suppressors don't receive any Second Amendment protection. This interpretation wasn't new. In fact, it mirrored the long-standing position taken by the Biden administration. Their argument was that suppressors are merely accessories, not protected arms, and that the NFA's restrictions are completely within constitutional bounds. That's where things stood, until now. And as we've seen, that position is starting to shift. The Trump DOJ's new position. Now here's where things get interesting. In a new brief submitted to the Fifth Circuit en banc panel, the Trump-era DOJ, under Attorney General Bondi and the newly formed task force, has made it clear: suppressors are arms, and they cannot be outright banned under the Second Amendment. This is a major shift from the previous stance. However, the brief is somewhat nuanced. While the DOJ now acknowledges that suppressors fall under the definition of protected arms, they also argue that the National Firearms Act doesn't impose a full ban. Instead, they claim the restrictions in the NFA are still in line with the Constitution because they stop short of completely prohibiting ownership. Even with that, the DOJ is urging the Fifth Circuit en banc to take another look at the case and overturn the earlier ruling by the 3-judge panel, specifically the part that claimed suppressors aren't protected by the Second Amendment and are just non-essential accessories. This marks a significant change in how the federal government is approaching suppressor regulations. You now have the Department of Justice openly stating that suppressors deserve constitutional protection, that banning them outright would violate the Second Amendment, and that the Fifth Circuit needs to correct the panel's earlier interpretation. The original case details. Back in 2022, both federal and state law enforcement officers executed search warrants at the home of Mr. Peterson in Louisiana. He also operated a gun store from a separate shop, which was either at the same address or nearby. A task force, made up of ATF agents along with around 50 other law enforcement officers, carried out the operation. During the search of his home, the key item that sparked this legal case was a single solvent trap. It was found inside a safe in his bedroom. That's what ultimately led to the charges under the National Firearms Act. In response, Mr. Peterson filed a motion to dismiss the charge, arguing that the NFA restrictions violated his Second Amendment rights. However, the lower court denied that motion, allowing the indictment to proceed. Peterson then appealed the decision to the Fifth Circuit. When the case reached a 3-judge panel in the Fifth Circuit, the court sided with the ATF and the arguments made by the Biden administration at the time. The Fifth Circuit's original ruling. In their decision, the Fifth Circuit's 3-judge panel noted that the question of whether suppressors qualify as arms under the Second Amendment was a first for their circuit. They also pointed out that from what they could find, every other court that had reviewed this issue had ruled against the idea that suppressors are protected arms. The panel analyzed whether suppressors are offensive weapons, tools of defense, or something used to project force, and they ultimately concluded that suppressors don't meet that standard. According to them, suppressors aren't weapons on their own. They argued that a suppressor, when not attached to a firearm, has no real use in self-defense. In their view, unless someone is throwing a suppressor as a weapon, it doesn't count as something that can strike or defend. Based on that reasoning, the court upheld the district court's ruling against Mr. Peterson. Understandably, this raised serious concerns for many in the 2A community. As a result, Mr. Peterson and his legal team decided to request a full en banc rehearing by the Fifth Circuit, hoping for a different outcome from a larger panel of judges. The government's changed position. At first, the Department of Justice, likely influenced by holdovers from the previous administration, argued that the petition for a rehearing en banc should be denied. They claimed the original ruling by the three-judge panel was correct, and that no further review was necessary. In earlier videos, I mentioned this was probably due to lingering influence from the Biden-era DOJ, and that the current administration and Attorney General's office might not have been fully aware of the developments in this case. That's now been confirmed. The Attorney General's office requested a delay in the proceedings, informing the Fifth Circuit en banc panel that they were considering a shift in position, especially in light of President Trump's executive order aimed at protecting Second Amendment rights. Now, with this newly filed brief, the Trump DOJ has officially changed its stance. As part of a broader review of their litigation approach to Second Amendment issues, something they link directly to the new executive order, they state that the United States has reassessed its position in this case. According to the brief, the Second Amendment does in fact protect firearm accessories and components like suppressors. Therefore, any restriction on possessing a suppressor places a burden on the right to bear arms. They go even further by saying that a complete ban on suppressors or similar accessories would violate the Constitution. In this filing, the DOJ clearly acknowledges that its earlier arguments, those likely made under the previous administration, were incorrect. They're now asking the court to reverse course and reevaluate the matter under this new understanding of Second Amendment protections. The DOJ's current stance on the NFA now, while the DOJ is acknowledging that suppressors are protected under the Second Amendment, they still maintain that the National Firearms Act, specifically its registration and tax requirements, is constitutional. Their reasoning is that these rules place only a limited burden on owning a suppressor and align with historical firearm regulations, especially since suppressors can potentially be misused for criminal purposes. Because of that, they say the original panel was right to uphold Mr. Peterson's conviction. That said, the DOJ believes the panel's reasoning in the opinion wasn't entirely correct and needs to be addressed. They're asking for the court to rehear the case, not just to consider it en banc, but for the original panel to re-examine their own decision and fix the flawed legal analysis. So to summarize, in their new filing, the DOJ is walking back the government's earlier position in this lawsuit. They now argue that suppressors aren't just accessories, they're protected under the Second Amendment. They also make it clear that banning them outright would be unconstitutional. However, they still defend the NFA's requirements, claiming they're not the same as a ban and fall within the government's authority to regulate firearms under historical precedent. Analysis of the NFA's constitutionality. On this issue of the NFA and its constitutionality, the DOJ argues that although the National Firearms Act's restrictions on suppressors' possession implicate the right to bear arms, the modest burden they impose does not violate the Second Amendment. Although a total ban on suppressors or other similar accessories would be unconstitutional, the Act's modest regulations pass muster. When I read this brief, I think that the AG's office here and kind of the administration is trying to walk a fine line between arguing directly against the NFA and still presenting a case for the en banc panel here in the Fifth Circuit to grant review to this case. The goal of the DOJ with this brief may be to get the Fifth Circuit en banc to take this case and find that suppressors are protected arms and maybe also as a result rule that the NFA's restrictions are a violation of the Second Amendment. Potential circuit split and Supreme Court review. The en banc panel here, reviewing whether suppressors are protected arms, and if an outright ban on these types of items is constitutional, would still be a huge decision since it would also create a much-needed circuit split that would then create again a circuit split nationwide. Because we've already had other circuit courts ruling that suppressors are not protected arms, that the NFA is constitutional, So even on the issue of whether suppressors are protected arms, if the Fifth Circuit finds that they are protected arms, that creates a circuit split that then is really needed to get this case and this type of issue before the Supreme Court. So I wouldn't say this is the most pro-2A brief I've ever read, but instead, maybe it's a little bit more strategic, and it's a strategic play by the DOJ and the 2A task force to get the AIN Bank here to grant review to this case. Now you have both Mr. Peterson and the DOJ stating that the panel here should take review for at least the reason to reverse what the three-judge panel said down below, and essentially reverse their finding that suppressors are not protected arms. Broader implications. This marks a significant shift, not just in this specific case, but in federal policy more broadly. It suggests that the Second Amendment Task Force may be taking real action to challenge long-standing anti-gun regulations, even in complex and contentious areas like suppressor laws. What I'm really watching closely now is whether the DOJ will carry this new position over into other ongoing cases. For example, there are suppressor ban challenges currently pending in states like California and Illinois. If the DOJ is now saying that an outright ban on suppressors is unconstitutional, will they step in and argue the same in those state-level cases? Their brief doesn't stop at suppressors either. They reference other firearm components and accessories, which raises the question, could this new direction also affect cases involving magazine bans and other similar restrictions? If they're serious about this new interpretation of the Second Amendment, we might see them getting involved in more of these cases, arguing that such bans also go too far. This could signal a broader shift in how the federal government approaches Second Amendment protections moving forward. Conclusion and future outlook. At this point, both sides agree the Fifth Circuit en banc should take up this important case. And more notably, both the defense and the DOJ now acknowledge that suppressors are protected under the Second Amendment. They also agree that the previous rulings, both at the district level and by the three-judge panel, were based on flawed legal reasoning. This is a major development and reflects a real change in how the DOJ is approaching these types of cases. It gives me a stronger sense that the full Fifth Circuit will choose to take this on. But even if they don't, the path remains open to bring the case before the Supreme Court, and now you'd have the DOJ backing the position that suppressors are indeed protected arms. I'll continue tracking this closely and share any updates as they come. As always, thanks for watching. Make sure to like, comment, and subscribe to stay informed on these critical developments.